warm good morning to all the participants. I am Madhu Khanna Lalli, Additional District and Sessions Judge, cum-faculty member. On behalf of the Chandigarh Judicial Academy, I welcome all the participants. Today's workshop is on general topics, specially selected, keeping in mind the work schedule of the participant officers. The first topic is Commercial Codes Act 2015 and the amendments made in the Code of Civil Procedure. Commercial Codes Act 2015 was initially brought into force in 2015 by the name the Commercial Codes Commercial Division and Commercial Appellate Division of High Courts Act 2015. In 2018, several amendments were introduced in the Act, and the name of the Act was changed to Commercial Codes Act 2015. According to Section 1, the Act extends to the whole of India. The words except the state of Jammu and Kashmir were omitted by Act 34 of 2019. The Act is basically a procedural code. The Act also contains certain important provisions such as restricting scope of the Act to commercial disputes, definition of commercial disputes, establishment of commercial courts, and defining their jurisdiction and powers. The object of the provisions of Commercial Codes Act, read with amended provisions of CPC, which is applicable to commercial courts, is to ensure that there is no unnecessary delay in disposal of the commercial suit. A purposive interpretation of the Commercial Codes Act and various amendments to CPC leave no room for doubt that the provisions of the Act require to be strictly construed. If the provisions are given a liberal interpretation, the object behind constitution of commercial division of courts, putting the matter on fast track and speedy resolution of commercial disputes will be defeated. The main aim and object of the Act is to provide means and ways for expeditious disposal of economic disputes. The purpose being to create a positive image to the investor world about the independent and responsive Indian legal system. The Act provides for a schedule which amends certain provisions of CPC. These provisions are applicable to commercial disputes of specified value, and the commercial division or commercial court shall follow the amended provisions. The Act has clarified that the provisions of the CPC, as amended by the Act, would have an overriding effect over any rules of the High Court or the amendments to the CPC made by a state government. We'll just share the government notifications. Can you please come and share the notifications? By notification dated 29/4/2022, courts of Additional District Judge 3 to 6 were empowered to be commercial courts in Ludhiana. Ludhiana already had a commercial court, which was of District Judge of the second rank. Pecuniary jurisdiction of the appellate commercial courts, that is of the District Judge level, is cases of specified value of more than rupees 50 lakhs So this is Ludhiana. This one, again dated 14/6/2019, is for the other districts in Punjab. The said courts were designated as commercial appellate courts. This one again dated 14/6/2019 is pertaining to Civil Judge Senior Division, Additional Civil Judge Senior Division and Civil Judge Junior Division having more than 5 years service in each district and subdivision in the state, and it would be called commercial courts. Pecuniary jurisdiction of these courts is to decide the cases of the specified value of rupees 3 lakhs to rupees 50 lakhs. Now this one is for the state of Haryana. Gurugram already had a commercial court. This notification dated 17th January 2020. So this is otherwise in letter and spirit the same, only it is for the state of Haryana. This is for the civil judges. It is again the same. Pecuniary jurisdiction is for the specified value of rupees 3 lakhs to rupees 50 lakhs. This is for the UT Chandigarh. Notification dated 18th July 2019. This is for the civil judges. And this is notification dated 18th July 2019 for the UT Chandigarh. This is for the additional district judges. They are called the commercial appellate courts. And this one is for the Honorable Punjab and Haryana High Court. This is minutes of meeting dated 13th May 2016, whereby constitution of commercial division consisting of a single judge to exercise the jurisdiction and powers conferred on it in terms of section 4 of the Act was recommended, and constitution of commercial appellate division consisting of a division bench to exercise the jurisdiction and powers conferred on it in terms of section 5 of the Act was recommended. Now, what is a commercial dispute? Commercial disputes, as defined in section 2C of the Act, enumerates 21 categories of the disputes out of which the commercial dispute may arise, and leaves the scope for addition of more disputes. Right now, there are 21 disputes which have been specified. The definition is restrictive, and every dispute arising from a commercial transaction without the same falling in any of the clauses cannot constitute a commercial dispute. So commercial disputes, I'll quickly refer to them. These are the ordinary transactions of merchant bankers, financiers and traders, export or import of merchandise or services, issues relating to admiralty and maritime, transactions relating to aircraft, aircraft engines, aircraft equipment, helicopters, including sales, leasing and financing of the same, carriage of goods, construction and infrastructure contracts, including tenders, agreements relating to immovable property used exclusively in trade or commerce, and franchising agreements, then distribution and leasing licensing agreements, then management and consultancy agreements. There are 21. I mean, it is all mentioned in section 2C. Then what is specified value? Section 2I defines specified value in relation to a commercial dispute to mean the value of the subject matter in respect of the suit as determined in accordance with section 12 of the Act, which shall not be less than rupees 3 lakhs or such higher value as may be notified by the central government. Now, jurisdiction of the commercial courts will be as per sections 15 to 20 of Code of Civil Procedure. Same rules are applicable to suits and applications under this Act while determining the territorial jurisdiction of the commercial court. Now, jurisdiction of commercial divisions of high courts is mentioned in section 7. And it is created only when the high court has ordinary original civil jurisdiction. The second proviso pertains to transfer and filing of suits under intellectual property rights and like suits pertaining to patents and designs which lie on the original side of High Court to be heard and decided by commercial division of High Court, and those which are pending shall be transferred in such commercial division of High Court. Now, section 8 of the Commercial Courts Act makes it clear that no revision or petition will lie against interlocutory order passed by commercial court. There will be no revision or petition. Use of word petition may appear to have prohibited petition under Article 227 of the Constitution of India. I mean, one may say that it is, but Article 227 has given unfettered powers of supervisory jurisdiction, and the power which is given by Constitution cannot be curtailed by any enactment. Therefore, against any such order against which no appeal is provided, petition under Article 227 of Constitution is maintainable. Then there is jurisdiction in respect of arbitration matter, which is dealt with in section 10. This section deals with jurisdiction of commercial courts in arbitration matters, and 3 circumstances are considered in this section. First is when arbitration is an international commercial arbitration. In such matters, if the matter is already filed in High Court, it will be dealt with by the commercial division of the High Court. But it must be noted that the commercial division of the High Court is created and established only where the High Court has original civil jurisdiction. This establishment is as per section 4 of the Act. Where there is no original civil jurisdiction of High Court, the commercial division of High Court will not be created there. However, it has been recommended in Punjab and Haryana High Court, as I just told you, by the minutes of meeting dated 13th May 2016. In such cases where the matter is not filed in High Court, the question of jurisdiction will not arise. Then the second is where arbitration matter is not pertaining to international commercial arbitration. Where the matter is filed in original jurisdiction of High Court, then all applications or appeals arising out of Arbitration and Conciliation Act 1996 will be decided by Commercial Division Court of High Court. Here again, if the High Court has got no original civil jurisdiction, the application of this section will not arise. And the third aspect is the arbitration matter does not involve international commercial arbitration. In such matters, appeals or applications will be decided by concerned commercial courts in the district. Now, section 11 bars the jurisdiction of commercial courts in certain aspects. See, commercial court is after all a civil court. Only some procedural amendments in respect of commercial disputes are given in the Act. Some rules and orders are amended, and some new rules and orders are inserted in CPC to expedite the disposal of commercial disputes. Therefore, the matters which cannot be decided by civil court cannot be entertained by commercial courts also, may it be a commercial dispute. Civil court cannot entertain a dispute which is within exclusive jurisdiction of cooperative court or revenue court, and therefore commercial court also cannot decide such disputes. So section 11 bars the jurisdiction of commercial courts where civil courts do not have jurisdiction. Then how do we determine the specified value? This is dealt with in section 12. Then determination of specified value of commercial dispute is synonymous to determination of valuation of suit in regular civil court. Section 6 of the Commercial Courts Act specifically states that the commercial court shall have jurisdiction to try all suits and applications relating to commercial disputes of a specified value, and that should not be less than rupees 3 lakhs. The specified value must be determined in accordance with Section 12, read with provisions of Court Fees Act. Clause A of Section 12 states that where the suit or application in commercial disputes is pertaining to recovery of money, then the valuation of that suit or application should include interest up to the date of filing of suit. That final amount, including interest till date of filing of suit, will be considered as specified value of that suit or application. The plaintiff or defendant, whosoever claims monetary relief, must plead and pray for recovery of amount along with interest as per the provisions of Order 7, Rule 2A CPC. Now this provision makes it mandatory to mention the details of interest. Then clause B refers to the specified value in respect of claim of movable property. Where the suit or appeal or application is for movable property or right therein, then the market value of that movable property on the date of filing of suit shall be taken into account for determination of the specified value of such property. The court fees will depend upon the nature of relief claimed, that is, where the suit is for possession or it is for declaration of rights only. Clause C refers to the suits of immovable properties or rights therein. It is same like movable property mentioned in clause B. It says that market value of immovable property as on the date of filing of suit or appeal or application shall be the specified value of that commercial suit, appeal or application. To reiterate, it needs mention that Maharashtra Court Fees Act and even Court Fees Act of other states and Suit Valuation Act make difference in respect of the court fees to be paid on suit only for declaration of right and suit for possession of the immovable property. But the suit valuation for the purpose of possession and declaration is same, and it is the market value of the property on date of suit through the court fee, though the court fee will be different depending upon the relief claimed. Specified value will depend upon the market value of the property. Clause D of Section 12 pertains to the determination of specified value in respect of the commercial dispute about intangible right. In common parlance, intangible means one which cannot be seen with eyes or is not in any visible form or is untouchable, such as goodwill, intellectual property rights, like damages for infringement on trademark, copyright or patent, etc. In such cases, the specified value shall be the market value of such property, which the plaintiff will estimate in his own eyes. Plaintiff himself will estimate his loss on infringement of his right on such intangible property. Now, for the purpose of determination of specified value in arbitration matters, which is mentioned in Section 12, subclause 2, the aggregate value of the claim and counterclaim as set out in the statements of claims, and that shall be taken as specified value for the purpose of determining the specified value and pecuniary jurisdiction of commercial court or commercial division court of High Court. Section 12(3) makes it clear that the order of commercial court or commercial division court deciding that the court has jurisdiction over the dispute cannot be challenged by way of appeal or revision under section 115 CPC. But the order of commercial court that it has no jurisdiction can be challenged in appeal or revision. Now there's very important aspect which has been introduced in the Commercial Courts Act, that is pre-institution mediation and settlement. The Commercial Courts Act has introduced section 12A providing for mandatory pre-institution mediations in all cases other than those cases which require any urgent interim relief under the Commercial Courts Act. I mean, the words have been written under the Commercial Courts Act. Now, these words have created confusion as there is no provision under the Commercial Courts Act to grant urgent interim relief. Thus, the Commercial Court can grant urgent interim relief only under CPC. Such pre-institution mediation has to be conducted through authorities authorized by the central government under the Legal Services Authority Act 1987. The process of pre-institution mediation has to be completed within a period of 3 months, extendable by 2 months with consent of the parties from the date of application made by the plaintiff. The time which has been spent in pre-institution mediation shall not be computed for the purposes of limitation under the Limitation Act 1963. If the parties to the commercial dispute arrive at a settlement, the same shall be reduced into writing and shall be signed by the parties to the dispute and the mediator. The settlement arrived at under this provision shall have the same status and the effect as if it is an arbitral award on agreed terms under subsection 4 of section 30 of the Arbitration and Conciliation Act 1996. Now there are commercial courts below the level of district judge. There are commercial courts at level of district judge and commercial division court of high court, which has the original jurisdiction, as we have just seen. So the appeals will accordingly go from the commercial courts below the level of district judge to the commercial courts at the level of district judge. The appeals from those courts will go to commercial division court of the high court. Otherwise, commercial appellate division of high court. So each appeal, the time frame is 60 days. Commercial court civil judge, the appeal will go within 60 days to commercial appellate court district judge level. Then the appeal from district judge level will go to commercial appellate division of high court within 60 days period. The Commercial Courts Act is not providing appeals against orders mentioned in section 104 CPC. And it refers only to Order 43 CPC. All appealable orders mentioned in section 104 CPC are not covered in Order 43 CPC. As Order 41 CPC has not been amended for the purpose of Commercial Courts Act, its provisions shall be applicable to appeals. Section 13 subclause 2 Commercial Courts Act makes it clear that there shall be no second appeal against the orders or decrees passed by commercial courts. I'll repeat, section 13 subclause 2 Commercial Courts Act does not provide for a second appeal. Then section 15 provides that all matters involving commercial disputes, including suits or applications under Arbitration and Conciliation Act 1996, pending in regular courts, have to be transferred to the respective commercial courts in accordance with the pecuniary value. Section 16 says that the Act will have overriding effect on the provisions of CPC. and its amendment. It clearly mentions that in case of conflict between any rules of the code, rules of jurisdictional high courts, or any state amendments made to the code, the provisions of the Act as it amends the code will prevail. There's a landmark judgment on this, Axis Bank Limited versus Meera Gehnani and others, 2019, SCC Online, Bombay, 358. Then what are the amendments made to CPC by the commercial courts? We'll just have a quick look at that. Institution of suits, section 26. In every plaint filed before the commercial court, facts shall be proved by affidavit, which shall be in the form and manner as prescribed under Order 6, Rule 15A CPC. This statement of truth in the form of affidavit is more specific, and it means that there is fear of prosecution if statement of facts turns out to be false. Section 35. That has been substituted. The original section 35 of CPC has been replaced by new section 35 for the purpose of Commercial Courts Act. The provision about costs has become more stringent. Subsection 1 says that the court has to determine 3 contingencies in respect of costs to be awarded. First is whether costs are payable by one party to another, the quantum of those costs, and when they are to be paid. The explanation to subsection 1 says that the costs shall be reasonable costs. The explanation also clarifies that the costs include the fees and expenses of the witnesses incurred, legal fees and expenses incurred, and any other expenses incurred in connection with the proceedings. As a rule, costs are awarded to the party who succeeds in litigation. But under the Commercial Courts Act, if the court is of the opinion that the party who succeeded had brought the litigation unnecessarily and could have satisfied itself with the stand of the opposite side, the court may award costs to defeated party from the successful party, but for this, court has to give reasons for awarding such costs. The circumstances mentioned in subclause 3 have to be taken into account while determining the costs by the court, awarded by the court. Now section 35A says that the limit of costs which was imposed by section 35A subclause 2 has been deleted, and hence there is no limit to the compensatory costs that may be imposed by court, of course subject to the limitation that may be imposed by the Honorable High Court in view of proviso to the said subsection. Then Order 5, issue and service of summons. By way of amendment to Order 5 Rule 1 CPC, for the purpose of commercial courts, it has been stated that the defendant can file the written statement within 30 days, but if he fails to file it within 30 days, the period can be extended by the court only up to 120 days subject to costs. I'll repeat, only word, and laying emphasis on the word only up to 120 days, that too subject to costs. Therefore, after first 30 days, the defendant is liable to pay costs that may be ordered by the court. If he fails to file the written statement within 120 days from the date of service of summons, it has to be noted, it is the date of service of summons. 120 days have to be counted from the date of service of summons and not from the date fixed for the court cannot take the written statement and cannot permit the defendant to file the written statement because his right stood forfeited by statutory mandatory provisions. This fact is further confirmed by amendment in Rule 10 of Order 8, wherein it is stated that the court has no right to extend the period of filing written statement. Now, the verification of pleadings has to be in accordance with Order 6. Rule 3A provides that the form of pleadings in commercial disputes will be as per High Court rules or practice directions provided for such disputes. A new Rule 15A has been inserted which pertains to verification of pleadings in a commercial dispute in a prescribed manner, that is statement of truth. In the absence of verification, the pleadings cannot be relied as evidence. Every pleading has to be verified by an affidavit signed by the party or one of the parties to the proceedings or any person who is acquainted with the facts of the case and authorized by such parties. If the pleading is amended, the same has to be verified again. Order 7 Rule 2A has been inserted after original 2 in Order 7. It says that plaintiff should state precise amount of interest in the claim. Sub-Rule 2 makes it essential for the party claiming interest to make a mention as to whether it is claiming interest as per Section 34 of the CPC or under contract or under any other law. Sub-Rule 2 requires that pleadings shall state rate of interest claimed, date from which it is claimed, the date up to which it is claimed, total amount of interest, the daily rate at which the interest will accrue after the date up to which it is claimed in the plaint. These details will help the court in granting a proper relief. Now, Order 8, written statement, set-off and counterclaim. Rule 1. The amendment is identical with the amendment inserted in Order 5, Rule 1 CPC. By way of amendment, it has been stated that the defendant can file the written statement within 30 days, but if he fails to file it within 30 days, the period can be extended by the court only up to 120 days subject to cost. So this is the same. From the date of service of summons, his right to file the written statement shall stand forfeited if he fails to file the written statement within 120 days. Rule 3A. This is a new rule introduced by the amendment and has far-reaching effects. It is obligatory on defendant to deny the pleadings more specifically and with reasons. The defendant in his written statement should state which allegation of plaint he denies, which he is unable to admit and wants the plaintiff should prove them, and which allegation he admits. Mere evasive or general denial will not suffice for the purpose. If the defendant has any other version about the fact, then he must specifically state his own version along with an affidavit. If the denial is not as per the rules, it will be treated as admission of fact. If the defendant disputes the jurisdiction of the commercial court, he must state reasons for the same and must make a statement as to which court will have jurisdiction over the matter. If the defendant denies the valuation of suit, it is mandatory for him to give correct valuation according to him. Then there is Rule 5. The proviso to Rule 5 makes it clear that if the denial of the pleadings is not as per Rule 3A, the facts or pleadings which are not denied specifically will be treated as admitted by a defendant. Therefore, denial should be specific and with proper and legal reasons. Rule 10. This rule gives a discretionary power to court to pronounce judgment if defendant fails to file his written statement. If the court does not give judgment, then it may require proof of facts even in absence of written statement. If the defendant is present in court, he has a right to cross-examine the plaintiff or his witness on the basis of plaintiff's own pleadings, but he cannot be permitted to cross-examine on the question of facts which he himself has not pleaded, nor can he be allowed to adduce evidence on such questions of fact which could have been pleaded by him by filing written statement. So the amended proviso takes away discretion of court to grant time to file written statement after lapse of 120 days from the date of receipt of summons, as the right to file the written statement after the said 120 days stands forfeited. Now, Order 11 lays down the procedure for discovery and inspection of the facts of the suit through interrogatories. The Act added disclosure along with discovery and inspection of documents. Under the new provisions, parties are required to file a list of all documents and the photocopies of all these documents at the stage of filing of plain written statement, specifying inter alia in whose possession the documents were currently, whether they are with the plaintiff or defendant or some other person. They are mandated to include a declaration on oath stating that they are not in possession of any document other than the photocopies of the documents they had already placed on record. The parties are not allowed to rely on any documents other than the ones mentioned in the list and whose photocopies had been filed without leave of the court. However, the Act has granted discretion to the court to award exemplary costs against a party who willfully, unreasonably, wrongfully, or even negligently failed to disclose all documents pertaining to the suit in their possession. So the disclosure would in nutshell mean list of all documents and its photocopies, to specify the person in whose possession the documents are, declaration on oath that they do not possess the documents, leave of court is required to rely on other documents, costs to be imposed on persons who do not disclose documents in their possession. Now, electronic records. Order 11 Rule 6 CPC has incorporated the relevant provisions providing procedural rules in respect of the same. This order, Order 11 Rule 6 CPC, is about disclosure, discovery and inspection of documents, and it is not about proof of documents. The provisions of Evidence Act are applicable to proof of documents. The word electronic record is not defined in this Act, and therefore the definition given in Information and Technology Act 2000 and the Evidence Act has to be taken into consideration. If one wants to produce and prove electronic record before court, he has either to produce original primary electronic record, that is the hard disk, camera, mobile or other device used in storing that original record, or he may give secondary evidence by complying with provisions of Section 65B Evidence Act, and if he cannot, then he may give it according to Section 65 and other provisions. Then Order 11 Rule 7 CPC makes it clear that the provisions of Order 13 Rule 1, Order 7 Rule 14 and Order 8 Rule 1A shall not be applicable before commercial courts. Other provisions of these orders will be applicable to commercial suits. The Act introduces a system of summary judgments through a new order 13A in the CPC. Summary judgment is given by the court without recording oral evidence in the scenarios where the plaintiff has no real prospect of succeeding on the claim, the defendant has no real prospect of successfully defending the claim, or in the absence of any other compelling reason for recording of oral evidence. In furtherance of its objective of early disposal of commercial disputes, Order 13A has been introduced to facilitate immediate judgment on some undisputed issues in a commercial dispute. Under Order 12, Rule 6 CPC, the decision can be given only on facts which are admitted by defendants. But in commercial dispute, the scope has been broadened and it applies when suit can be decreed in part or on admitted facts as well as on issues which, though disputed, there is no substance in dispute or denial, and such dispute which has no force of law. Now here no oral evidence is permitted and the entire process has to be conducted within 30 days from the date of application for summary judgment. Now what is the procedure for summary judgment? An applicant may apply for summary judgment at any time after summons has been served on the defendant. But no such application will be entertained after the court has framed the issues in respect of the suit. An application for summary judgment shall not be made in a suit if that is originally filed as a summary suit under Order 37. The applicant may rely on documentary evidence in support of its application. The date for hearing a summary judgment of a commercial dispute must be fixed after giving a notice period of 30 days to the respondent. The respondent has to file his reply within 30 days of the receipt of notice of application of summary judgment or notice of hearing, whichever is earlier. Order 15 of CPC deals with disposal of suit at first hearing, but the said order has been omitted by the Act. Now, case management hearing. This is very, very important. Order 15A. An international practice of case management hearing has been introduced in India for the first time through a new order inserted in CPC as Order 15A. This allows the court to make a timeline and fix dates for the proceedings of the matter. Rule 1 provides that the first case management hearing has to be held by the court within 4 weeks from the date of filing of affidavit of admission or denial of documents by all parties to the suit. Rule 3 provides that arguments have to be closed within 6 months of the first case management hearing. Rule 7 provides that no adjournment for case management hearing would be entertained for the sole reason of non-appearance of counsel, provided that if adjournment of hearing is sought in advance by moving an application, in that event the court may adjourn the hearing on payment of costs on this ground. But if the court is satisfied that there is a justified reason for non-appearance of counsel, it may again adjourn the case on terms and conditions as deemed appropriate. But otherwise, non-appearance of counsel should not be a ground for adjournment of case management hearing. Rule 8 provides non-compliance with case management hearing. It says that non-compliance shall not be condoned by the court only upon payment of costs. It might also result in forfeiture of the party's right to conduct the proceedings. If there is non-compliance with case management hearing, it might result in forfeiture of the party's right to conduct the proceedings. In extreme cases of willful non-compliance, the court has the discretion to dismiss the plaint or allow the suit as the case may be. Then there is Order 18 of the CPC, which deals with hearing of suit and examination of witnesses and consists of provisions pertaining to written arguments. Rules 2 and 4 have been amended to suit the aim and object of the Act. Time limits have been inserted for actions of parties. Filing of written arguments has been made mandatory by the amendment. As per Rule 2(3)(a), parties have been mandated to submit concise written arguments under distinct headings within 4 weeks of commencement of oral arguments. Revised written arguments may be filed within 1 week of the conclusion of arguments. Copy of written arguments has to be furnished simultaneously to the opposite counsel or party. No adjournment is to be granted for the said purpose without recording reasons. The court may limit the time for oral submissions. Earlier, there was no such time restriction. Rule 3(a) mandates that a party himself wishes to appear as a witness. He shall appear before any other witness has been examined by him, unless the court permits him otherwise, that too after recording the reasons. Rule 4(1)(a) provides that the affidavits of all witnesses should be filed simultaneously at the time directed in the first case management hearing. Then Rule 4(1)(b) states that a party shall not be allowed to lead additional evidence by affidavit of any witness, including the witness examined, unless sufficient cause is shown. Now that means permission of court will be necessary for leading additional evidence. Rule 4(1)(c) provides that a party has a right to withdraw its affidavit at any time prior to commencement of cross-examination without any adverse inference being drawn. It further provides that the other party may use it as evidence and rely upon the admissions made in such withdrawn affidavit. But it has to be noted that the wording is restricted only to admissions and not specifically permitting drawing of adverse inference. Now affidavits, Order 19. Rule 4, it says that courts have been empowered to control the evidence by being permitted to decide the issues which require evidence and the manner in which such evidence is to be recorded. The commercial courts even have discretion to exclude evidence that would otherwise have been produced by the parties. They have been empowered to redact or reject any affidavits which in their view does not constitute admissible evidence. Now Order 20, Judgment and Decree. Rule 1 stipulates that judgment must be pronounced within a maximum period of 30 days from the date of conclusion of hearings. But the Act has provided a maximum time period of 90 days commencing from the date of conclusion of arguments for pronouncing the judgment. We can just share the amendments at a glance. There's no one here. Now, pre-institution and mediation process, section 12A, time in law is 3 months. Filing of written statement, order 5, rule 1 and order 8, rule 1, 30 days, maximum 120 days from the date of service. If plaintiff is unable to file all documents under his control, if plaintiff is unable to file all documents under his control with plaint because of some difficulty, order 11, rule 1(4), maximum 30 days on filing of plaint with permission of court. Inspection of documents of opposite sides by both parties, order 11, rule 3(1), 30 days from date of application. Copies to be supplied, order 11, rule 3(4), 5 days after order 11, order under order 11, rule 3. Filing of reply to application for summary, production of documents, etc. All processes till final hearing on application. Decision on summary judgment application. Order 15A, rule 6, 4 weeks. Date of first case management hearing, order 15A, rule 1, 4 weeks. Framing of issues, evidence of parties, oral and written arguments, order 15A, rule 3, 6 months. Written arguments, order 15A, 4 weeks. Judgment, order 21, rule 1, 90 days. Judgment to be sent by court on email or otherwise to parties. Appeal, section 13, 60 days. Section 26, which have been amended or inserted, section 26, section 35, order 5, rule 1, order 6, rule 3A, order 6, rule 15A, order 7, rule 2A, order 8, rule 1, order 8, rule 5, order 8, rule 10, order 11, order 15A, order 18, rule 1A, 1B, 1C, under rule 4, order 9, rule 4, 5, 6, order 20. So this is verification of pleadings in a commercial dispute. This is the section reproduced. The appendix have been given in the act itself. Those have to be strictly construed. A suit for recovery of main profits against tenant, bank by landlord is held to be a commercial dispute as it is not dispute that the immovable property was being used exclusively in trade and commerce. Jagmohan Behel versus State Bank of Indore, 2017, SCC online. So that's it. If you have any questions, you may please message them. Any questions? Thank you so much.